So some takeaways for us from this case is that this case provides employers and employees alike with certainty concerning which tests will be applied in cases of alleged family status discrimination. Self-accommodation efforts are still important, but they don't go to the point of whether a complainant experienced discrimination in the first place. Rather, it goes to whether there's a form of reasonable accommodation that can be made. And evidence concerning the complainant's self-accommodation efforts only becomes relevant in that second stage, so it shouldn't be explored at all in the beginning of determining whether discrimination occurred or not. This decision is especially useful in the context of the ongoing pandemic because we have right now the return to the office for many employers, but we've also had interruptions to schooling, family health, and other impacts. So we really think that family status is going to be at the forefront of most employees' workplaces more than ever before. And we anticipate seeing numerous requests for flexible work hours, continued working from home arrangements, as well as a large amount of flux as employees and their families may become sick.
And what they said was a physician's note, which is what the individual had in this case. It was basically a note that said the person was medically exempt from wearing a mask. That wasn't sufficient. The service provider was entitled to more information. And they were entitled to information that certifies that Mr. Pelche had been diagnosed with a disability, what the nature of that disability was, although as we all probably are familiar with, that doesn't mean the diagnosis itself, but just the general nature of what that disability is, the nature and the scope of the restrictions that were caused by that disability, and then also the accommodations the individual required.